accounts, buy and sell property, title a vehicle, and manage all digital assets, and give a big, solid, long definition of what that includes. At least you've got something then to point to with third parties to say, hey, my agent can access my email account. It's in the document. You can stick it in a revocable trust. It's harder to stick it in a will, because we don't like those to be 90 pages long. But one of the interesting things in the world that's developing is this idea of ante-mortem or pre-mortem estate plan challenges. You know, when you study those cases in law school, you always have the feeling like if only the decedent could have come and testified. I'm not under undue influence. I want to leave my estate to Bobby. That's who you want to judge the credibility of, right? The decedent. Well, you can't have that case until after they're gone. So it actually, at least arguably, makes more sense to have those challenges while the person is still alive. Right? I mean, it does. We don't really want to see will challenges anyway, but if we're going to have one, that'd be better evidence to be able to have a doctor say, yeah, I just visited with this person and this is what they said, and have the person themselves there. So some states have started statutorily authorizing pre-mortem will challenge proceedings, typically where the testator would start the proceeding and say, I want a declaration that my will stand up. Notify everybody that could object later and have the proceeding now. I think you could do the same thing in South Dakota. If you read our declaratory judgment statutes, they're broad. They say something to the effect of, if you've got a dispute that's justiciable, you can bring it forward for a declaration from the court. I don't see why you couldn't use that to say, you know, we don't know what the person's last will and testament is actually going to be. It's an ambulatory instrument. But we wanted an order that this will, executed on such and such a date, it was validly executed, was not the subject of undue influence, fraud, mistake, incapacity, duress, and have your day in court. We also have something that works very similar to this in our conservator statutes, because our conservator statutes allow a conservator to make a will with court approval. So you can go to court and say, Judge, this person probably doesn't quite have enough going on to make a will, but we want to make a will. And you can have your hearing and notice all the potential errors and you put together a will. I don't think you could later undermine that based upon undue influence or incapacity because of the nature of the proceeding that authorizes it. Currently now, Alaska, Ohio, North Dakota, and Arkansas have specific kind of procedures by which you can have an ante-mortem will proceeding. We now have a proceeding for revocable trusts, as well as irrevocable trusts, where you can do this in South Dakota. We don't yet have one for wills. But listen to this, because typically you do these with a deck action. You go to court, and you have your day in court. Maybe nobody shows up and it's a signature, but you have your day in court. This is what our trust statute says. A judicial proceeding to contest whether a revocable trust was validly executed may not be commenced later than the first to occur of 1, a year after death, so you get a 1-year statute of limitations, or 60 days after the trustee sent to the person who's contesting the trust a copy of the trust, a notice informing them of the trust's existence, the trustee's name and address, and the time allowed for commencing the proceeding, i.e. 60 days. You send it in the mail, you give them 60 days, and they're barred. Notice is to be given to all the beneficiaries of the trust, as well as all heirs at law, so the people that are getting something, and the people who would have gotten something if the person was intestate. And with respect to notice, personal service is kind of encouraged, but not required. You can mail it, but you got to mail it certified. But that's as formal as we get. We have also updated some of our decanting statutes. Decanting is the power of a trustee to essentially change the terms of a trust by distributing assets to a new trust. We used to require notice of that, like we saw notice in the anti-mortem trust challenge statutes. We got rid of the notice requirement. So now the trustee can decant without notice. DAPTs are one of my favorite things. Asset protection trust. You create a trust for yourself, name a different trustee, it's irrevocable, and boom, you creditors can't get to it. Self-settled asset protection spendthrift trusts, specifically authorized and codified in 2009. We now have a fee-shifting statute. So if someone challenges that as being a fraudulent transfer and they lose, they have to pay your fees. Just one more arrow in your quiver. Ethics. If you represent a trustee or an agent, power of attorney, or a conservator, or some kind of fiduciary, you have all the standard attorney ethical rules that apply to you. The duty to keep information confidential, the duty to be competent, the duty of loyalty and avoid conflicts of interest, the duty to be a zealous advocate. So, multiple choice. Debbie has two daughters, Abby and Betsy. She has a will that says, all of my daughters equally, I nominate Betsy as my personal representative. Very simple. Debbie dies. Betsy hires you to probate the estate. Abby calls, and she says, I suspect Betsy removed Mom's grandfather clock from the house, and she refuses to discuss it, but I think it was there and now it's gone. Okay? Actually, fairly common type scenario, right? If you've done estates. Who is your client? A, Abby. B, Betsy. It's the personal representative. C, the estate. D, all three. E, Betsy and the estate. Or F, wait until this part of the presentation is over and then I'll raise my hand. Okay. So you'd think that would be fairly straightforward, right? Who the client is in a standard type situation like that. Well, here's part of the problem, is we don't really know what a trust is, ultimately. We all work with trust, we know what trusts are, but we really don't know. And there's three basic theories. One is that we're bifurcating property interest. We've got equitable interest and legal interest, because the trustee owns stuff, but can't enjoy it, and the beneficiaries enjoy it, but can't own it. Okay. Two is contract. Agree to trust agreement? It says agreement. Grantor and trustee hereby agree that we'll treat property as follows. Okay. It's kind of like a contract. C is it's an entity, because it's not really a contract, because the trust can sue and be sued, hire and fire advisors. A contract can't hire advisors. It's just a contract. It's just a nexus of relationships. So each of these theories is only partly true. So when it comes to who's the client, there's three theories. The first theory is your trustee is your client. That's simple. You can avoid conflicts of interest pretty easy if you've only got one client. Not easy maybe, but easier, right? The problem sometimes the courts have with that is the trustee is typically not paying your bill. The trust is. And that troubles the courts. Well, how can the trustee be the client, but the trustee doesn't have to pay for the bill? The other theory is this joint client theory, where you represent the trustee and the beneficiaries. Well, that addresses the fee payment concern, right? And certainly we have concerns with a trust where the trustee is really not doing their job and the beneficiaries are getting hurt by it. They should have some kind of remedy. So the courts are tempted to look at the joint client theory. Some of them say that they're just equal clients. Some of them say that the trustee is the primary client, the beneficiaries are derivative clients. And then some say actually the beneficiaries, this is Delaware, who claims to have really good trust law, by the way, relative to South Dakota, but some of them say that the beneficiaries are your clients and the trustee is a derivative client. So if the trustee is the primary client, if we're going to have this theory, at least let's have the trustee be your primary client. then the trustee is entitled to duties of confidentiality and loyalty, but the beneficiaries are derivative clients, so they get some duties, but we really don't know how much. Lots of unanswered questions. The third is the entity theory. Trust can be like an entity. And here we basically use the corporate model and we say, trustee is not your client, the trust is your client. The trustee and the attorney are co-agents of the trust. Makes sense why the trust would pay your bill then. As an agent for the trustee would engage an attorney as a co-agent for the trust, and the attorney would be responsive to the trust rather than directly to the trustee. The trust attorney as a co-agent would have duties to the trust as well as the beneficiaries thereof, at least derivatively. But this is really the minority approach. The entity theory is the least popular of them. So what do our model rules say? Okay, model rule 1.7. It says, this is your conflict of interest rule, and it talks in the comment about when you represent an estate. It says, conflict of interest questions may arise in estate administration. We're looking for our answer here, right? Depending upon the circumstances, a conflict of interest may be present. In estate administration, the identity of the client may be unclear under the law of a particular jurisdiction. Under one view, the client is the fiduciary. Under another view, the client is the estate or trust, including its beneficiaries. But in order to comply with the conflict of interest rules, the lawyer should make clear the lawyer's relationship to the parties involved. In other words, we really don't know who your client would be, but you better be clear about it. That's really what the rule says. Okay, is that all we've got? We've also got an ethical opinion 95.-1. And I'm gonna be a little critical of the opinion, but I don't want it to be read as being critical of the ethical board, because those people work very, very hard and do a wonderful job. But this is really the best statement of law we have, because the model rule just punts the ball down the field and says, be clear about it, but we have no idea. Here you've got a husband and wife who works with a law firm, and they put together a estate plan. The husband has 2 daughters, and the wife does not. The husband dies, leaving an estate for a trust for his wife, and then the wife becomes incompetent. The husband's 2 daughters are appointed her guardians and manage her assets for her. She goes to the nursing home, and they're paying the nursing home bill. And they're also trustees of the trust, and they're using trust money from the husband's estate to pay for herself. Then the wife dies. And so a cousin is the heir under the wife's will. Cousin calls up the attorney and says, politely I assume, is there any money there? And the attorney says, no, it's all gone. We spent every dime. There's nothing left in this woman's estate. Then the clients call the attorney and say, found a couple little life insurance policies on wife's life, $1,000 each. Can you figure out who those pay to? So the attorney makes a call or two. Turns out that it was to husband, no contingent, so it pays to her estate, right? So they're estate assets. And so their attorney reports this to these clients, and they say, well, keep your mouth shut. The attorney said, well, shouldn't we tell the cousin, because she's the heir, and it's not a lot of money, but they say, just be quiet about it. I don't know why. Maybe they were just tired of paying his bill. Maybe they were mean. Who knows? But that was their specific direction to their counsel. So the attorney writes to the ethical board and says, what the heck am I supposed to do here? And of course, the ethical board says, well, first of all, we need to figure out who your client is. And the beginning of the opinion says, this is a difficult question. Really shouldn't be that hard, should it? Shouldn't it just be the 2 daughters? And here's what the opinion says. It's the opinion of this committee that if you believe the action which the stepdaughters have instructed you to take is not in the best interest of the estate and its beneficiaries, then you have a duty to make a disclosure to the cousin of what you have learned pertaining to the insurance policies. Whether the conduct of the stepdaughters is not in the best interest of the estate and its beneficiaries is a question you must answer. So it seems to say the personal representatives are your clients. But when they start to do a cruddy job, you've got other clients. Now, look at this too, because I assume this lady was in the nursing home, right? She's in the nursing home. Who's paying for the bill? Department of Social Services, Medicaid program. They get repaid. They get repaid before the cousin does. So is the Department of Social Services his client too? I would assume so. They get paid before the cousin does. What does he do after he discloses this? Does he have to withdraw then? I mean, you clearly have a conflict of interest. You have a client say, don't do that, and then you're providing that information to another client. Or do they stop being your client after you've made the disclosure? It's almost Halloween, so I thought I'd just leave you with something very, very scary. That's all we've got. You know, we don't have an answer. Some states are adopting specific rules that say, trustee's your client. Let's not be silly with this. So you probably think from time to time or wonder, you know, what would it be like if I went back to law school? You know, and I'm back at the law school now. And I always used to wonder, you know, law school is really hard. Would it be that hard now that I've practiced law and mastered some of this content? Or would it be pretty easy? I wonder. And so one of the things we like to do, of course, with our students is we start out and we just use this Socratic method to see what they already know that they don't really know they know. You know, you start Contracts 101 and you just say, what's a contract? You know, get us to stand up and says, it's an agreement, you know, and you just try to find out what they didn't know they already know. So I'm teaching trust and wills now, and I think one of the questions that would be a fair question, maybe in the first day of class, would be to say, what is a will? Because everybody can define a will, everybody knows that word. It's a word in their vocabulary, but do they really know what we would consider more of a legal definition? So I can ask you, what is a will? Come on now. It's a dead giveaway. Thank you.
Does anyone have any questions? I can just hang out if you want to take a break.
Where did he get his jokes?
All right, thanks, Tom. We'll take a short break, and
Right.
here at 10 will be our last presenter. Thank you.